Most people think a living trust is like a bulletproof vest for their estate plan. Put one on and you're fully protected. The truth? A trust alone can leave holes big enough for your wishes to slip right through, especially after you're gone. I'm attorney Stephen Howitz with Zimmer and Rens here in Wisconsin, and I help families protect their assets, their loved ones, and their legacy. Today I want to talk to you about why a living trust, while powerful, isn't the whole story, and how leaving out the other essential pieces of your estate plan can undo everything you worked so hard your entire life to put together. If you've got a trust or you're thinking about creating one, you should hear this, and you need to hear this. First, let's clear up what a trust does. A living trust can keep your estate out of probate, give you privacy, and help manage your assets during your lifetime and after you pass. But it doesn't take care of everything. One big gap: guardianships for a minor child. Anybody with young children knows that they need to take care of this. A trust cannot name who will raise your kids if something happens to you. That has to be done through a will and potentially approved by a court. Without it, the court will make the choice for you, and you may not know this person, and they may not be who you'd want caring for your children. Now there's something called a pour-over will. Even if you have a trust, not every asset will automatically fall right into it, especially if you're acquiring property later, accidentally leave something out, or forget you even had something. A pour-over will makes sure anything outside of the trust gets moved into it after you pass, so nothing is left floating under state laws that you didn't choose. Third, a trust usually isn't the best place for sentimental items or specific personal belongings you want to give to certain people. A will allows you to make those personal, heartfelt gifts directly, and I always recommend doing it during your lifetime. You might as well see the joy somebody has getting something from you that you really wanted them to have. Then some documents handle your wishes while you're still alive. A living will spells out the medical treatment you do or don't want if you can't speak for yourself. A power of attorney lets someone you trust manage your finances or healthcare decisions while you're incapacitated. Without these, you're leaving your care and your money in limbo if something happens to you before you pass away. And yes, there are even situations where you might need an irrevocable trust for maximum protection against creditors, lawsuits, or Medicaid planning. Most people don't think about it until it's too late, especially with Medicaid planning. There's a 60-month look-back window that's extremely important and needs to be paid attention to by a professional. A living trust is an incredible tool, but it's not a one-stop shop. Without the right supporting documents, wills, directives, powers of attorney, you risk leaving big gaps that can cost your loved ones time, money, peace of mind. Estate planning isn't just about having a trust. It's about building a comprehensive plan that works for you, your life, your family, and your future. If you're ready to make sure your plan works when it matters most, call my office today. Let's make sure there are no holes in your protection, because when it comes to your legacy, close enough is never good enough.